What is an asset protection trust? An asset protection trust provides protection to assets other than your principal home. A property protection trust provides protection to your principal home. An asset protection trust is different from a will trust in that the will trust only comes into force when the will is read, in other words, after a death. Whereas the asset protection trust comes into force as soon as it is set up, therefore giving protection from creditors, bankruptcy, divorce, family disputes, coercion, deception, and local authorities' charges for care home fees. Another advantage this arrangement has over a will trust is that it protects both parties, whereas with a will-based property protection trust, if both parties required care, there is no protection against care home fees. Current situation: property valued at £200,000 with a mortgage of £120,000 leaves £80,000 at risk. In the future, property valued at £300,000 with no mortgage leaves £300,000 at risk from creditors, bankruptcy, divorce, family disputes, coercion, deception, and local authorities' charges for care home fees. With a trust. With the protection of a trust, your property is substantially protected from being seized by creditors or bankruptcy, via a divorce, by local authority for long-term care fees. There are also tax benefits for yourself and future generations. Current situation: with a trust in place. A property valued at £200,000 with a mortgage of £120,000 and a charge in favour of your trust for £80,000, this means that none of your property is at risk. In the future, with a trust in place, a property valued at £300,000 with no mortgage, leaving £300,000 at risk, and a charge in favour of your trust for £300,000. This means that none of your property is at risk. The charge is always for the entire value of the property, so there is never any equity to be claimed against. You may now be thinking that this is all very well, but who controls this trust? The trustees can be yourselves and/or family members, or any trusted person acting in line with your instructions. If you do not have anyone suitable, or if you do not want to put them in a potentially awkward family situation, you can appoint a professional trustee who would act in accordance with your instructions after your death or before if required. It is similar to you having a personal bank account and a business bank account. In both cases, it is your money. In one, it is in your own name, and in the other, your company name, but you own the company. Because the trust is a separate legal entity, it can put a charge against your property in the same way as the mortgage company or secured loan company could, but you do not pay any monthly payments. But when a creditor, counsel, or other party looks at your accounts and checks with the land registry, they will see a charge against the property for the entire value of the property, leaving them with no equity to claim against. But what if you want to move or remortgage? You, as the trustee, removes the charge. Then once you have moved or remortgaged, you reinstate the charge. The trust lasts for 125 years. This means that the trust can benefit generations to come, including inheritance tax benefits. So what can it protect against? From creditors, bankruptcy, divorce, family disputes, coercion, deception, and local authorities' charges for care home fees. This is an overview of how these trusts work. We would need to conduct a full appraisal of your individual situation before advising on which particular version of a trust offers the most comprehensive protection for your individual circumstances.